today's video, we're diving into the realm of divorce proceedings and shedding light on an important aspect: financial orders. So if you're going through a divorce or you're simply curious about the legalities involved, this is the video for you. To fully understand why a financial order might be necessary, let's first discuss what a divorce settlement entails. A divorce settlement refers to the agreement reached between divorcing spouses regarding their financial assets and responsibilities following the divorce. It covers various aspects such as the division of money, property, pensions, savings, investments, and more. Additionally, the settlement may address important matters like child support and maintenance. In April 2022, no-fault divorce laws were implemented in England and Wales, allowing couples to state that their marriage has broken down without actually assigning blame. However, financial issues including the division of assets and child custody arrangements still need to be addressed separately. This is where financial orders come into play. In the UK, divorce settlements are guided by the Matrimonial Causes Act 1973. While an equal split of assets is the starting point, the court takes into account various factors when determining what each party is entitled to in a matrimonial settlement. It assesses the unique circumstances of each case to achieve a fair outcome. To navigate this process effectively and protect your assets, professional divorce solicitors can provide valuable assistance. Sometimes divorcing couples in the UK cannot agree on how to divide their assets, leading to contention. In such cases, involving the court becomes necessary to resolve the dispute. This legal process results in a financial order, also known as a contested order or an ancillary relief order. Furthermore, if one party suspects the other of hiding money before the divorce, a financial order may also be required. When ordering a financial settlement, the courts consider several factors outlined in Section 25 of the Matrimonial Causes Act 1973. These include financial resources, obligations and responsibilities, income, earning capacity, and the standard of living. With full disclosure of all assets and finances by both parties, the court aims to reach a fair settlement that addresses the needs of both individuals. Applying for a financial order is advisable as soon as possible after initiating divorce proceedings in the UK. It helps determine how assets, property, and financial arrangements will be divided between the divorcing couple. If both parties have already agreed on a fair settlement, they can submit a consent order to the court for approval instead of applying for a financial order. However, in general, it is crucial to consider applying for a financial order within 12 months of the decree absolute, the final stage of the divorce process. Now, let's walk through the general process of obtaining a financial order. Step 1. Attend a Mediation Information and Assessment Meeting, MIAM. This meeting informs you about mediation and its potential benefits. If you decide to proceed with a court application, you'll receive Form FM1 from the mediator. Step 2. Fill in Form A. This form serves as a notice of your intention to proceed with a financial order application. It outlines the type of financial order you are seeking and your intent to apply for one. Step 3. Wait for information from the court. After submitting Form A, the court will provide you with a notice of proceedings and a first appointment date. If you qualify for free remission, you won't have to pay a court fee at this point. Step 4. Fill in Form E. Both you and your ex-spouse must complete a Form E before the first appointment. These forms must be exchanged and copies sent to the court, disclosing your financial situation fully and honestly. Step 5. Attend the first appointment. The purpose of this appointment is to clarify issues and save cost. If further information, expert advice, or valuations are needed, the court can provide directions on how to proceed. Step 6. Attend the Financial Dispute Resolution Appointment, FDR. This court hearing aims to resolve financial disputes with the assistance of a judge, who helps determine a fair division of assets. Step 7. Attend the final hearing. If no agreement is reached at the FDR, the case proceeds to a final hearing. During this hearing, the judge makes a binding decision based on all of the evidence presented. Step 8. Issuance of the final order. Once a final order is made, it becomes legally binding for both parties and compliance is required. Any changes can only be made if both parties agree or if the court permits it. While obtaining a financial order is an important legal process, it can also be costly and time-consuming, especially in contentious cases. Fortunately, there are alternatives to consider. Alternative 1. Mediation. Attending mediation sessions with a professional mediator can help both parties reach an agreement outside of court. Option 2. Collaborative law. In this approach, each party assigns lawyers to negotiate and find mutually acceptable agreements. Option 3. Arbitration. Assigning the task of reaching a settlement to an arbitration service can offer an alternative to court proceedings. By exploring these alternatives, you may be able to reduce costs and resolve your financial disputes more efficiently. Remember, seeking professional legal advice is crucial to ensure the best possible outcome for your unique situation. Even with the most amicable of divorces, it can still be worthwhile to consult with a solicitor for expert advice on how to proceed. These days, there's many online solicitors that work out cheaper and easier than meeting in person. JustAnswer, for example, only costs £5 for a trial, which could be far less than a traditional in-person appointment. One of my colleagues used their service and saved over £270 on an outstanding parking ticket. I've linked that offer in the description below, and if you use that, you'll also be supporting Money Nerd, so thank you.